Welcome to this tutorial video. This video introduces the domain Cultural Integrity in the Climate Change module. We introduce the concepts covered in this domain and the relevant human rights instruments. The issues covered in this domain relate to the cultural rights of Indigenous peoples, including to practice cultural, spiritual and religious customs, as well as to maintain and develop traditional knowledge and cultural expressions. The Paris Agreement says that climate adaptation should be based on and guided by the best available science and, as appropriate, traditional knowledge of Indigenous peoples and local knowledge systems. Recognition of these rights are critical for ensuring that Indigenous traditions, customs and ceremonies are protected from exploitation or environmental degradation due to climate change or climate change related measures, and for respecting Indigenous peoples' traditional knowledge systems and their integration in climate and environmental policies. The first category in both surveys is cultural integrity. The UN Declaration on the Rights of Indigenous Peoples, or UNDRIP, says that Indigenous peoples have the right to manifest, practice, develop and teach their spiritual and religious traditions, customs and ceremonies. The right to maintain, protect and have access in privacy to their religious and cultural sites. The right to use and control their ceremonial objects and the right to the repatriation of their human remains. The Convention on Biological Diversity, or CBD, says that parties must respect, preserve and maintain knowledge, innovations and practices of Indigenous and local communities embodying traditional lifestyles relevant for the conservation and sustainable use of biological diversity. The questions in this category assess whether Indigenous peoples enjoy these rights in the context of climate change. This includes looking at harms and potential harms to cultural rights caused by climate change impacts, and then whether there are any violations of these rights caused by climate change related laws or policies. It is useful to understand the difference between human rights harms and human rights violations. It is important to note a human rights harm can refer to any suffering experienced by an individual due to actions or omissions that negatively impacts their fundamental rights. This can happen even if it is not a formal violation of a right or is not illegal. For example, rising sea temperatures impacting fish stocks on which a community depends. This may negatively impact or harm the community's right to food. A human rights violation occurs when there is a breach of international or national human rights law, and when the responsibility of a state or other actor has been settled based on the actor's actions or failure to act according to their obligations in international or national human rights law. For example, carbon credit projects or similar, which might use areas of Indigenous land in a way that does not align with the rights of Indigenous peoples to land. This may be a violation of these rights by the state or a private business. Climate change litigation is a developing area. It is important that an issue is not described as a violation when it is actually a human rights harm that needs further investigation in order to establish whether a violation has occurred. In some instances, determining whether or not a violation has occurred will involve a complex assessment of the state's budget, priorities, policies, and measures, taking into account whether the state took sufficient action to prevent reasonably foreseeable harm to human rights. The community survey then asks you to collect disaggregated data to see if there is a disproportionate impact of climate change and related policies and laws on specific members of Indigenous communities. The second category is cultural heritage and is only present in the national survey. Article 31.1 of UNDRIP states that Indigenous peoples have the right to maintain, control, protect, and develop their traditional knowledge, including knowledge of properties of fauna and flora. In international standards related to biodiversity, states are called upon to formally recognize this. The Convention on Biological Diversity calls on parties to respect, preserve, and maintain knowledge, innovations, and practices of Indigenous and local communities relevant for the conservation and sustainable use of biological diversity, and promote their wider application with the approval and involvement of holders of such knowledge, innovations, and practices. The question in this category looks at whether climate change-related laws, policies, and measures recognize the unique contribution of Indigenous traditional knowledge, innovation, and practices. For example, if a country has a wildfire risk reduction policy and the policy recognizes relevant Indigenous communities and incorporates their traditional fire management processes. If you would like more information about the different kinds of climate-related laws and policies listed, these are explained in the video on climate change-related instruments, laws, and policies, which you can find on the tutorials page of the Indigenous Navigator.